Supreme Court seems to side with web designer opposed to same-sex marriage. The Christian graphic designer who wants to restrict her wedding-related services to ceremonies honoring heterosexual unions had a case heard by the Supreme Court. The justices are anticipated to decide how to reconcile claims of religious liberty with laws forbidding discrimination based on sexual orientation, which was left unresolved in 2018. Despite a state law that prohibits discrimination based on sexual orientation, the conservative majority of the Supreme Court appeared ready to rule on Monday that a graphic designer in Colorado has the First Amendment right of free speech to refuse to create websites honoring same-sex marriages because of her Christian faith. A decision like that would be the most recent in a line of triumphs for religious individuals and organizations, particularly Christian ones, at a court that has moved to the right in recent years. Additionally, it would weaken the 2015 established right to same-sex marriage, which two sitting justices have urged their fellow justices to reconsider. In order to avoid overturning various anti-discrimination laws, it appeared that several justices who were leaning in the designer's favor were looking for limiting principles. They looked at the distinctions between companies that sell goods and those that engage in artistic expression. Justice Brett M. Kavanaugh stated that the case comes down to a fairly narrow question. He continued, "Are they more like the restaurants and the jewelers and the tailors, suggesting that those businesses are not engaged in protected speech, or are they more like, the publishing houses and the other free speech analogs?" Other judges emphasized the distinction between a client's message and the designer's message. The issue of whether the speech in question expressed the maker's point of view or the couple's point of view was at the center of much of what Justice Neil M. Gorsuch said. Others questioned whether there was a distinction to be made between discriminating against gay couples and refusing to promote same-sex marriage in messages. Justice Amy Coney Barrett said, "It's about the message and not about the sexuality of the couple." And Justice Samuel A. Alito Jr. questioned whether it's fair to equate opposition to same-sex marriage with opposition to interracial marriage, asserting that there is a distinction between discrimination based on race and sexual orientation. He cited Justice Anthony M. Kennedy's majority opinion in Obergefell v. Hodges, which established a constitutional right to same-sex marriage in 2015, which stated that honorable people opposed such unions on the basis of religion. The bottom line, however, appeared to be that despite the state anti-discrimination law, the court would not order the designer to create personalized websites honoring same-sex marriage. The three liberal judges on the panel expressed serious concerns about the potential harm that a decision in the designer's favor could have on gay rights and anti-discrimination initiatives. The court might decide that a commercial business open to the public, serving the public, that it could refuse to serve a customer based on race, sex, religion, or sexual orientation for the first time in its history, according to Justice Sonia Sotomayor. According to Justice Barrett, the court's decision on where to draw the lines in this case was crucial because they were difficult to draw. "Whatever our decision," she continued, "this case obviously applies to others." The case involves Lori Smith, whose design business claims to serve gay clients, but would only provide a wedding-related service for heterosexual unions. She argued that it was unconstitutional for the government to require her to provide those services to gay and lesbian couples. Kristen K. Wagoner, a lawyer with Alliance Defending Freedom, a conservative Christian group that represents Ms. Smith, said her client served all people, including those who identify as LGBTQ, but objected to producing designs that convey messages at odds with her faith, no matter who asks her to create them. She believes same-sex marriages to be false, Ms. Wagoner said of her client. There were some points of agreement during the argument. Off-the-shelf products, even ones that express a message, must be sold to everyone, both sides agreed. Software that merely provided a template, Ms. Wagoner said, does not express the designer's views about same-sex marriage. If it's a plug-and-play website where the couple, for example, is putting in their names and using their website, then you don't have compelled speech because you don't have a speech creator, she said. Both sides also seemed to agree that Ms. Smith was free to put a standard statement on all of her wedding websites along the lines of this one, proposed by Justice Alito, Made with Love by Amber, who believes that a valid marriage is a union between one man and one woman. Eric R. Olson, Colorado Solicitor General, said that was lawful so long as it was on every website, adding that a website designer like that will lose a lot of opposite-sex couples as potential clients as well because they don't want to be seen with that message. Justice Alito said the basic concession was a significant one. "You're making a tiny sliver of an argument," he told Mr. Olson. Justice Elena Kagan said she did not know how to think about a similar hypothetical situation that seemed to undermine some of the distinctions the court was drawing. What if, she asked, a web designer made the phrase "God blesses this union" a standard part of every wedding website? Those identical words, Justice Kagan said, could imply different messages in different contexts. Ms. Wagoner, Ms. Smith's lawyer, said context changes meaning, adding, "My body, my choice" means something different to an anti-vaxxer or a pro-abortion proponent. Despite all of its complications, Monday's case, a sequel to one from 2018 involving a Colorado baker that failed to yield a definitive ruling, is expected to settle the question of whether businesses open to the public and engaged in expression can refuse to provide services to potential customers based on their religious or other convictions. Mr. Olson, Colorado Solicitor General, noted that Ms. Smith had not turned down any prospective gay customers or faced punishment and had instead sued preemptively. Justice Kagan said that was a source of frustration. "It really depends on the facts and on what exactly Ms. Smith is being asked or compelled to do, and that matters," Justice Kagan said. "And we have a case without any of that in it." Lacking such facts, the justices and the lawyers arguing the case substituted hypothetical scenarios. Brian H. Fletcher, a lawyer for the Biden administration arguing in favor of the Colorado law, said a ruling for Ms. Smith would allow a photographer to refuse to take corporate headshots for women based on objections to the message that women should be leaders in the workplace. Justice Ketanji Brown Jackson asked whether a shopping mall that wanted to mimic the atmosphere of the movie It's a Wonderful Life could refuse to include children who were not white in its pictures with Santa. "That may be an edge case," said Ms. Wagoner, adding that under the First Amendment, this court has protected vile, awful, reprehensible, violent speech in the past. Justice Alito built on Justice Jackson's question, asking whether a black Santa at the other end of the mall could refuse to be photographed with a child who's dressed up in a Ku Klux Klan outfit. Mr. Olson said such costumes are not protected by the Colorado law, and Justice Kagan added it would presumably be the same Ku Klux Klan outfit regardless whether the child was black or white. Justice Alito responded with apparent sarcasm. "You do see a lot of black children in Ku Klux Klan outfits," he said. Lower courts have generally sided with gay and lesbian couples who were refused service by bakeries, florists, and others, ruling that potential customers are entitled to equal treatment, at least in parts of the country with laws forbidding discrimination based on sexual orientation. The owners of businesses challenging those laws have argued that the government should not force them to choose between the requirements of their faiths and their livelihoods. Their opponents say that businesses open to the public must provide equal treatment to potential customers. The case before the justices, 303 Creative LLC v. Lenny's, number 21-476, is a free speech challenge that only incidentally concerns religion. Ms. Smith's lawyers had also asked the Supreme Court to decide whether the Colorado law violated her right to the free exercise of religion and to consider whether to overrule an important precedent from 1990, Employment Division 5, Smith. In that case, the Supreme Court ruled that laws that are neutral and applied generally could not be challenged on the ground that they violated the First Amendment's protection of the free exercise of religion. That decision, arising from a case involving the use of peyote in Native American religious ceremonies, is unpopular among conservative Christians, who say it does not offer adequate protection to religion, and with some of the justices. Last year, the court's three most conservative members, Justices Alito, Gorsuch and Clarence Thomas, said it was time to overrule the 1990 decision. In the new case from Colorado, though, the court limited its review to the question of whether the Colorado law violates the First Amendment's protection of free speech. The precise question the justices agreed to decide is whether applying a public accommodation law to compel an artist to speak or stay silent violates the free speech clause of the First Amendment.